Discovery is being given to us as if we're living in a snow globe and it's just swirling around us and we're constantly having to put it together.
Sounds like Bryan Kohberger's defense attorneys are getting a snow job from the state of Idaho.
And it sounds like they're getting materials, but they have to piece it together.
How big of a shovel are we going to need to sort out this mess? The Kohberger case has been a blizzard with no end in sight. I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have the wonderful Yoli Medina with us. Yoli, how are you doing?
I'm fine, thank you. Thank you for having me.
We have a snow globe in the Kohberger case. So what is this all about, Andrew?
It's a persisting issue that as of the day we're recording this still has not been addressed. And one of the things is just I'm not going to say there's confusion, there's conflicting information. For example, the probable cause affidavit, which Yoli's going to tell us about in a minute, did it deceive us all by stating that two Washington State University officers had Bryan Kohberger's car on their radar in late November 2022, yet when the author of that probable cause affidavit, Brett Payne, went on the stand, he said he wasn't even aware of that information until just before Christmas of 2022.
I mean, part of your affidavit talks about WSU officers finding white elantras. And I believe there was an officer that you had some communication with. Do you recall the date you had that communication?
I do not recall the date.
No. Did you have some messaging system exchange with this officer to talk about that?
Yes, ma'am.
Is that the only means of communication you had with this officer?
No, ma'am. I believe I spoke to him on the telephone as well.
When you spoke to him on the telephone, how did that relate to the date of the messaging?
It would have likely been, if memory serves, it would likely been that same day.
Okay. Does December 20th, 2022 sound familiar to you?
Yes, ma'am.
So this conversation with this officer from Washington, it related backwards to when he noticed an elantra. Is that right?
Yes, ma'am.
But when he noticed it, you didn't know about that yet. Is that also correct?
That is correct.
Okay, so you don't know about him or talk to him until December 20th, 2022, correct?
Yes, that's correct.
Wait a minute, Yoli, the probable cause affidavit kind of led me to believe that the Elantra was on the law enforcement's radar as early as late November. Now, I guess that's not the case.
Well, it was on the radar of the Washington State University Police in November of 2022, according to the affidavit. And I'll just read it. On November 25th, 2022, Moscow Police Department asked law enforcement agencies to be on the lookout for a white elantra in the area. On November 29th, 2022, at approximately 12:28 a.m., Washington State University police officer Daniel Tanego queried a white elantra registered at WSU. As a result of that query, he located a 2015 white elantra with the Pennsylvania license plate LFZ 8649. And this vehicle was registered to Bryan Kohberger, who was residing at 1630 Northeast Valley Road, apartment 201 in Pullman, Washington. And it says 1630 Northeast Valley Road is approximately 3/4 of a mile from the intersection of Stadium Way and Cougar Way, last camera location that picked up the white elantra. So according to Tanego, he queried this elantra on November 25th, 2022. Then on the same day, up at approximately 12:58, which was half an hour later, Washington State University officer Curtis Whitman was on the lookout for a white elantra and located the 2015 white elantra at 1630 Northeast Valley Road in Pullman in the parking lot. 1630 Northeast Valley Road is an apartment complex that houses Washington State University students. And Officer Whitman also ran the car and it returned to Kohberger with the Washington tag. Now, this is Payne speaking. He says, I reviewed Kohberger's Washington State driver's license information and photograph. The license indicates that Kohberger is a white male with a height of 6 feet and weighs 185 pounds. Additionally, the photograph of Kohberger shows that he had bushy eyebrows. Kohberger's physical description is consistent with the depiction of the male DM saw inside the King Road residence on November 13th.
Now, the way that's written, the way the page we're looking at now is written, it talks about how the same day, the day being the end of November of 2022, Whitman was looking for the white Hyundai Elantras and located one there in Pullman, Washington, in the parking lot. So the way the probable cause affidavit is written is very deceptive. I mean, look at that. The first couple of lines talk about Officer Curtis Whitman at WSU in late November of 2022, locating this Hyundai Elantra. Then all of a sudden at the end of line 4, as you pointed out, Yoli, is Brett Payne. He reviewed Kohberger's Washington State driver's license. So the time frame and the speaker jump in one line. And it's when I read that, I mistakenly just assumed that meant that Kohberger was on law enforcement's radar at the end of November 2022. Well, it was on Washington State University Police Department's radar, but not on Payne's radar. Am I reading that correctly now?
That's what it reads. But if you're not reading it, if you're not careful in reading it, it sounds like Payne was aware of it in late November 2022. But if you look at it closer, it goes, it talks about what Officer Whitman, what he did. He located it, and then he ran the car and it returned to Kohberger with a Washington tag, and then it said, I reviewed Kohberger's Washington State. Well, when the issue would be, Mr. Payne, when did you review Kohberger's Washington State driver license information and photograph? So if it was, when?
Well, from the testimony we just heard, Ann Taylor drag out of Payne, sounds like he didn't even know about any of this until December 20th. I mean, it's not unusual. As a former reporter, it's not unusual for different police departments to have, a real kind of a feudal kind of a thing where they're competing. They're not actually working together. The different law enforcement agencies, from jurisdiction to jurisdiction, from state to local, from state to federal, they don't always work together. And that's kind of what it sounds like to me here. And you had indicated correctly that maybe it's the fault of the reader for not reading it correctly. I think it's the fault of the writer for being so deceptive in writing that. That's deceptive.
It can be, the way it's written can be viewed as deceptive or misleading, but if you read it carefully, it sounds like he reviewed the license of Kohberger and saw the bushy eyebrows, but there's no date there when he reviewed it. So it is misleading in that it talks about the date late November. But the other thing is, the reason why these Washington State University officers were looking for the white Elantra was because of Moscow PD. They put out the alert. So if the Whitman and Tanego had that information, I would think that once they got that information, they would have given it to Moscow PD, because those are the Moscow PD put out that alert.
Well, that's a mystery. Do we know, did Washington State University put it out? And did WSU put it out and Moscow ignored it? Or did WSU fail to put it out? I mean, it could go, we don't know. But from the testimony that we just heard, it sounds like the point is, it wasn't on the radar of the Moscow Police Department. And had it been, and that's always been a question of mine. In a much earlier episode, I had asked, how come these guys had spotted this and they found somebody who looked to have these bushy eyebrows and it didn't go anywhere? Why was it a whole month until they, kind of got onto the guy and followed him out to Pennsylvania? That's always been a question. And this doesn't, I don't think this really resolves that question. It really doesn't. These two police agencies were not working together.
That's what it sounds like. It sounds like they were, I'm sure, if Moscow Police Department put out, to local law enforcement in the area to look out for a white Elantra, that Tanego and Whitman would have reported it to Moscow PD once they discovered it. So
I agree 100%. The next issue is that the Kohberger defense is saying that the state is just not cooperating. That's why there was this 3-hour and 30-minute motion to compel hearing. Eliza Masath, the co-defense counsel, gave Judge specifics, saying that the state's flurry of discovery is just not addressing specific items that are needed, such as the actual language of subpoenas that were used to gather evidence.
Where discovery is being given to us as if we're living in a snow globe and it's just swirling around us and we're constantly having to put it together. So, you've asked us several times, what can I do to help you guys get your work done? This is one of those things. Let us see the subpoenas so we can overlay this in our timeline.
And Brett Payne on the stand had the nerve to, very, very matter-of-factly, but had the nerve to say, wow, if you want these extra videos, and we have thousands at least of them, of videos, you're going to have to go to our evidence room and look at them. And that's just wrong. That's just wrong in my view.
Yeah, I don't see how there has to be some, the prosecution has to be involved, the prosecutor, because those are in the possession of law enforcement and those are his witnesses. So you can't just bypass the prosecutor and go to the evidence room.
No, and in fact, Ann Taylor cited some law which I actually read and analyzed, and it basically just says that you can't defend yourself by saying, oh, somebody else has it, oh, it's in the evidence room, oh, the FBI has it, oh, the state has it, oh, the crime lab has it. No, there's actual law on this, and Ann Taylor cited it to the judge.
We are requesting from you in the context of what's in the possession and control of the state. Your Honor, the State versus Pendleton case says that any law enforcement, and this includes the prosecutor's office, it includes their staff, it includes any law enforcement that worked with them on the case. In this case, you're looking at Moscow Police Department, Idaho State Police Department, Idaho State Police Forensics Lab, and FBI agents, to name a few. So what those entities have and have developed are within the possession and control of the prosecutor.
So you can't just say, oh, you have to come to our evidence room, or, oh, the FBI has it. That Pendleton case was cited by Ann Taylor a couple of weeks prior to our recording this episode, when she filed the objection to the state's motion, which is still secret. It's been held secret, but apparently they said that the probable cause affidavit is now irrelevant. So Ann Taylor cited this Pendleton case, which I read, and the case basically says, no, the prosecution has the obligation and the burden to come forward with stuff, and it cites all kinds of other jurisdictions that are in agreement. You can't, even the FBI, if you're asking the prosecutor in a case for material, they can't hide and say, oh, well, the FBI has it. Oh, we sent them a 2E letter. You can't just rely on all that stuff. It's ridiculous.
Right. And because a defendant has a right to confront all his accusers, everybody who investigated him. And if it was an FBI agent, well, then he has a right to ask questions of that FBI agent and get information that they used and what they prepared to get a charge against him.
Yeah, so I'm wondering how it was that they felt, the prosecutor did. They felt that they were ready to go to trial. They wanted to go to trial now this summer. I mean, school's out, it's June, and they wanted to go to trial now. So I'm wondering, how is it that they would have been ready to go to trial in June of 2024 now that the school buses aren't in the way? Apparently, that was the reason they were ready to go. But how would they have been ready to go now if there's all this stuff that's hidden in the evidence room and at the FBI?
I have no idea. I have no idea what's going through their minds. It just seems so crazy. I don't know. What do you think, Lainey?
I think it seems like bad faith. I think that if it's something that the defense is aware exists, that means that the prosecution was aware that it existed at some point. So I think it doesn't make sense that after asking and asking and asking and asking for all these things, that now it's, oh, you're going to have to go to somebody else to get it. Out of all the 52 terabytes you're going to give someone, why is that not a part of it? I think that it seems bad faith, and I think that it's going to lead to more problems down the line.
It's crazy. And so then the next thing that I thought was really pertinent while we're talking about a snow job is Taylor didn't use that word. Masath kind of said, we're in a snow globe. But Taylor kind of was very clear about saying, look, some of the stuff that we've been told here is simply untrue.
Your Honor, item 2B in our fourth motion to compel is item 224. That's the cast viz log. The court heard last week Detective Mowry say, I don't have any of those, except I found these other items that we'll give you now, which were not Mowry's cast viz logs. The hard part for us about this one, Judge, and I have to make a record, I think you can order them to double check, but the hard part of this for me is that on January 9th, we asked for these cast viz logs. And the response was from the state was cast viz does not produce logs. And that's just not true. It does. It's capable. It produces logs. You've heard that in the testimony.
So she's saying, look, he said something on the stand that's just not true. I mean, these cast viz logs, he's saying that, he said that they're just not available. And she says, nuh-uh, that's just not true. So that kind of changes the credibility of pretty much everything that was said on the stand, in my opinion. Am I being too harsh?
Well, it was the Ray that said that the cast viz logs do exist, right?
Yes.
Okay. So, yeah, so she's using her expert to educate the judge on what really exists and what doesn't, because it seems that Mowry was not being forthcoming, and either he doesn't understand that the cast viz logs exist, or he's just trying to be intellectually dishonest. That's what I
That's
think.
one of the things that I'm wondering, is that it's something that seems like it would be easily provable. So the fact that she needs an expert to come on, and that she has the confidence to have the expert come on and explain that, means that it could be probably cross-checked and it shouldn't be an issue.
Yeah.
Yeah. So the state's only response to these specific requests, and they went into a lot of detail, item number 263 and item 342. I mean, there have been 15 different very specific requests for discovery, and 2 now motions to compel. And so the state's only response to all this was, and it probably goes to the snow globe quote from Eliza Masath, Assistant Prosecutor Ashley Jennings simply fell back on saying, hey, we've given you a ton of stuff.
To date, we've given 15,691 bait stamped pages of discovery. So for a little context, this is about a 2-inch binder. It would be about 39 of these. We've given 13,758 bait stamped photographs. That's about 34 of those binders of photographs. We've given 911 AV dumps. Those are digital files. In addition to a massive hard drive, about 50 terabytes full of discovery. And that includes audio, video from about 285 interviews, 15,000 video clips from approximately 79 businesses, 8,000 video clips from approximately 10 residences, 417 files containing call detail records, multiple terabytes of records for 11 computer devices, 17 cell phones, multiple social media accounts, and 4 tower dumps.
It's hard because I feel like in the way that she's framing it, it's almost like, oh, we've been giving you so much and so much and so much. But it's like, if you've given so much, it's like, what's a couple more specific things? It's hard. I feel like now with technology, it's very easy to transfer data. It's like, you want a PDF, like, here, take it. I think it's ridiculous at this point that they're just like, okay, go to other people to get the stuff now. Where it's stuff that they should have had originally. I don't know. I think that their argument is they're asking too much, but even if they are asking for a lot, just give it to them. I don't know.
Oh yeah, there's the cast viz logs. There are a lot of videos that had been mentioned that they don't have. There apparently were a number of other items that Cyrey said should be there. By looking at what he has, you can tell that there's an awful lot more. And so, I mean, they can talk about all these AV dumps and photos and 35 binders. But if they haven't, it sounds like a snow job to me. If you talk about volume and not the quality of what you're producing,
Yeah.
meaningless.
Well, I wanted to ask too, because obviously the judge can't just pull out his phone and Google right now. But as far as like the log files that they're looking for, isn't he able to cross-check that and then just demand that they hand it over?
I think all he has to do is issue a motion to compel. I don't think the judge has to really do any research beyond what they told him to do. I mean, I could see him writing on his legal pad as they were going through and saying, well, item 329, and they told him what they need. And I think it's a simple matter of having his law clerk write up, I hereby compel the prosecution in the state of Idaho to turn over X, Y, and Z. And if they don't, they could be sanctioned by not allowing them to turn over to produce other evidence at trial. It's as simple as that.
So like the expert that came on, Cyrey, that was evidence for the judge. So the testimony of the expert is evidence for the judge that it does exist, and
Yeah.
So he has to take that into consideration. They didn't cross-examine, the prosecution didn't cross-examine Cyrey and challenge him on whether it exists or doesn't exist. If it didn't exist and they were truthful about it, then the prosecution would have cross-examined Cyrey and would have cross-examined him on the very fact as to whether the cast viz logs exist. And so, they didn't. So the judge can take that as true, or I mean, there's no other controverting evidence except Mowry saying that they don't exist. So he can order, he can order them to produce it or to compel them to produce it. And what I'm afraid we're going to hear is, we don't have it.
I was really wondering how it was that the state did not cross-examine Cyrey when he went on the stand. I couldn't believe that. I thought that was just incredible. That were they unprepared? Did they not have the technical expertise? Did they think that they should just let it go? I mean, sometimes there's a witness that you feel just hasn't made any good points, and so what's the point? But in another case that we're following in another episode, in the Karen Reed case, every time the prosecution puts on a witness, when they're done, the defense gets up and turns the whole thing around. And there are multiple examples, and we would encourage you to watch our Karen Reed episode, viewers, if you haven't, because witness after witness after witness has come on to testify for the state. But as soon as the defense attorneys get up and cross-examine them, they turn into witnesses for the defense and they raise reasonable doubt. So analogously to this case, had the state gotten up and either Ashley Jennings or Bill Thompson gotten up and cross-examined Mr. Ray, one of two things would have happened. Either we would have seen that he really does know his stuff and he really is going to be an excellent witness come time of trial, or maybe there would have been another result. I don't know, but I couldn't believe that they didn't cross-examine him. That was...
Well, they did the same with the genetic DNA or the genealogy DNA witnesses, expert witnesses that back last year. They didn't cross-examine them, and then they also filed a notice that they weren't going to cross-examine them. So it's kind of like, okay, and you got to let us know.
It makes no sense. It just, to me, it makes no sense. I mean, just cross-examine, what's the basis for time after time after time. He said, it's my opinion that. Well, ask him just simply, what's the basis of your opinion? And I'm not against Cy Ray. I'm just saying that if you're on the other side of the litigation, you get up and you cross-examine the guy. I mean, to just let it sit, I think is not a good litigation practice. I'll just say that. That's as far as I'm going to take it.
Well, and this was a motion to compel, so it's not a trial, but still, you have an officer saying it doesn't exist, and maybe because Maury was out of order, or he was the week before, and maybe they didn't. I have no idea why they didn't cross-examine him. I'm baffled as well, even though this was a discovery hearing for trying to get information that, your witnesses are saying they don't have it, and you have an expert saying that it exists.
Okay, here's a little teeny tiny little minor point. A little teeny tiny little minor point, I think. But is it a big point? They've been talking about this 51 or 52 terabytes all along. I don't know if you caught it, but just now Ashley Jennings was saying we turned over 50 terabytes.
I didn't catch that. I didn't.
It may or may not mean anything. I don't know, but it's just, I don't know. There's no precision here. There's a lack of precision. There's a lack of precise thinking. There's a lack of, okay, here is what we need. Here's why we want it. Just give us our order to compel.
I mean, it was one day of videos. I mean, I don't understand.
I don't either. Okay, so remember my email correspondence back and forth with Steve Gonsalves? Mm-hmm. I got another email from him, and here it is. Hello, Andrew. We have received a response from the prosecution team regarding our previous questions and concerns from the last hearing, and we are grateful that they took the time to address them. They have requested that we keep this information confidential, and we will honor their request by not misusing their trust. Since the beginning of this ordeal, our family has been diligently working on piecing together this investigation. We have been fighting to be involved in our daughter's pursuit of justice from the very start, and we will continue to do so until a conviction is reached. We have been advocating for our involvement in seeking justice for our daughter from the very beginning, and we will continue to do so until a conviction is secured. No family should ever be ostracized from participating in any aspect of defending their child in a court of law. And then he just goes on to say that his prayers are with everybody that was involved in the case. I had emailed Mr. Gonsalves and said, I know you're working on something. Remember, he said that he feels that he's a little bit smarter than some of the people on the prosecution team, and he was able to analyze some of the electronic data better than them. And so I just asked him for his work. Well, here he's saying, look, we got some work, and they've asked us to keep it confidential, which is too bad. So I responded to him by simply saying, hey, that's okay. I understand, but at such time as you do want to share it, get back to me. So.
Well, I'm glad that the prosecution is talking to them, or giving them a response to questions they have. I mean, that's a good thing, I think.
Mm-hmm.
I don't know how they do it in California, but in the states where I work, there are victim advocate offices. And when you've been a victim of the crime, the prosecutor's job is to gather evidence, put it together, litigate the case, and try the case against the accused defendant. That's the prosecutor's job. So a long time ago, some of the states, including the two in which I practice, have said that kind of leaves the victims out of the loop. It kind of leaves them out of the loop. And so they've opened very active victim witness offices, which I've worked with on occasion.
Yeah, I too. I have as well.
Okay.
And we have that program here. And they also offer some counseling for victims, things like that. Because it's true. I mean, the prosecution is busy working up the case. It's like sometimes when you're in a trial and your client is there, you're too busy doing the case to be able to, that's why it's always good to have another person, because then you're too busy to be able to communicate with them. Then the other attorney can relay what's going on and you can focus on the trial. So that's true. I just wonder if they have that in Idaho, this victim witness.
I don't know. From my conversations with Mr. Gonsalves and others, I don't think either they don't have one or they have one, they don't fund it and it's not very active. I don't know which it is. I don't know which it is. So any closing thoughts before I move into another little teeny tiny little area?
I just want to say, I think it's funny the comparison you made to the Karen Reed case. I will say the witnesses in this case have definitely been a lot more professional, not bringing in random things and staying on topic. So it's kind of jarring to see the difference. But at the same time, I'm interested in seeing what happens, because either these logs exist or they don't. And that's all the defense is asking for. I mean, they're asking for a lot of other things that they haven't gotten. But this should be something that even if they don't have it, they should be able to get it, in my opinion. I think it exists in the universe unless it was intentionally scrubbed. And if it was intentionally scrubbed, why? I mean, out of all the information we hoard in today's times, we have, so like, if you make an account and you change your username, half the time they'll store your username, so something from 10 years ago will still be visible. I'm sure this possible to get this stuff. I don't know how it escalated to this point.
Yeah.
A lot. Yeah. It just seems like so much. Like, just get the necessary things that you need to prove that it was Bryan Kohberger who did it. And when I look at all these terabytes and all this complication, I mean, I think the jury's going to get lost.
Yeah.
Because it seems like it seems like Ann Taylor is asking for specific things, and they're just giving her a big snow globe of stuff. Here you go. Look. Okay, do you really need all that information to prove somebody did a crime?
Yeah,
No.
exactly.
Otherwise, what they have is white Elantra and bushy eyebrows, which if somebody comes for a silver Toyota and thin eyebrows, watch out for me. I'm gonna start changing out my brows.
Now, I was watching a channel. I'm not going to mention the channel, but I was watching a channel, and Yoli, there's no trial date in this case yet, correct?
Not that I've seen. No.
Well, no, there's not. But I'm watching a network, which I actually like them, but I'm not going to name them. I was watching a network that did a special on what's going to happen on the March 3rd, 2025 trial date. That's never been set. There's never been a trial date set in this case. They discussed it in a February 28th, 2024 hearing. They discussed it. Remember, they discussed it, and Thompson wanted to make sure it was in the summer so the school buses don't get in the way. And Ann Taylor was saying, we can't rush it because, I don't have the material. The material I have not had a chance to thoroughly analyze and prepare. If you force me to trial, that'll be grounds for an appeal for ineffective assistance of counsel. So that was way back in February, and they left it hanging. After that hearing, they did set up discovery deadlines. They set up the discovery deadlines, and they, set up hearing dates. For example, the hearing we've been talking about in this episode. But there was never a trial date set. And this channel, actually, it's the same channel. Again, I'm not going to name it, but they actually did an hour-long special on the case against Bryan Kohberger. It's like, how objective is that? How about the case for the Idaho 4 murders? But anyhow, so right? I just wanted to tell our viewers that if they, because people like to go down in the comments and tell us we're wrong. I saw on this other network that the trial date has been set up for March 3rd. Yeah, guess what? we know you saw that somewhere else.
And that hearing is where Bill Thompson said, "Oh, I happen to have a proposed date for a trial," and the judge said, "So do I." A proposed date, and it turned out to be March 3rd, 2025, but it wasn't set.
No. It was not.
I remember Bill Thompson saying, "I have pink highlighter here with the March 3rd." It wasn't set.
No, it wasn't set. I mean, it was a proposed date, but we don't know. And Ann Taylor, if I remember correctly at that hearing, she even said that would be the earliest I would be able to do it, but that's pushing it.
Yeah.
So, okay. All right. Closing thoughts, Lainey.
No, thank you guys so much for watching up until this point. Be sure to like, comment, and subscribe. You have to let us know that you want Yoli to have her channel. We're trying to push Yoli to be a YouTuber. But yeah, no, it was awesome having you today. Do you have any final thoughts, Yoli?
No, I think we covered it all, and I thank you for having me here. And I can always talk about the Idaho 4 case. I can't even speak. So thank you.
Everybody, be kind and respectful. You see people in the grocery store, you see people at the gas station, be kind, respectful, because you don't know what they're going for. And in our comments down below, we ask you to do the same. We do delete all the comments that personalize. Don't tell us that we're idiots, because we try. But I did have to delete a couple of really nasty comments, not against us so much this week, but against some other people. And it's like, just don't waste your time, because we will hit the remove button. So thank you for joining us. Be kind, be respectful. We don't mind if you disagree with us, but be kind and respectful. And I hope you have a great day. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts, and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions. And that's that.
And that's that.
Crazy. This is the case that keeps on giving and keeps on confusing everybody.
Right?
So, Yoli, yeah, you should start your own channel. I mean, we don't want you to leave us. We want you to be a regular guest on our channel.
Yeah, I like this shorter, when it's shorter, it's not like these long live streams. So I gotta work on it. So but on Karen Reed, I won't be able to do the Karen Reed one. But what they had the forensic people come on and testify. Is that what happened?
Well, yeah, they finally had a couple of state police crime unit people come on and testify, and it made the case worse, and it just was true to form. As I said in this episode, the prosecution keeps bringing these witnesses on, and then the defense turns them around. You're not even going to believe this, but they had one witness talking about how they were looking at the Karen Reed Lexus SUV in the Sally Port, which is a fancy word for their garage. And the expert from the Massachusetts State Police was on the stand for a half a day, if not more, and for about a half hour, if not more than that. We were looking at a photograph of the SUV. And so we're looking at the SUV, and he's talking about the SUV, and people are walking around and kind of lurking behind it and all that. Okay, fine. This is the SUV that Karen Reed was driving. All right. Now, the next day, we get to the cross-examination by defense attorney Alan Jackson, and he says, "That's backwards, isn't it?" "Well, what do you mean?" "That's a mirror image of the SUV, isn't it?" "Oh, you were on the stand. Isn't it true you were on the stand yesterday for half an hour and you never mentioned it?" "Well, I don't know how long I was in the stand." "Well, isn't it true that this is a mirror image? Let's take a look." Well, the state police officer had to admit that it was a mirror image. And then the next line of questioning was, "Well, you were on the stand for a half hour and you never mentioned it, did you?" And not only that, but the prosecutor, Adam Lally, he never asked you about that, did he? No. So, I mean, now this is relevant. You might think I'm nitpicking.
No, I
Go ahead.
no, I understand what you're saying
So
about
now,
the mirror image.
here's the SUV. All right. Here's the SUV. Now there's a witness around the back, kind of lurking in the back there, kind of lurking. And this would be the driver's side. Now there's a horrible example, but there's somebody lurking around by the driver's side. Well, in the mirror image, that would be the passenger side where the light was smashed, and it's relevant because this was the Michael Proctor. We think nobody ever admitted it was him. He's the lead investigator who is under investigation by the FBI himself, and he's lurking around in the area where that tail light was smashed. So the implication being, what's he doing back there? What is he doing lurking around back there? And also, why? I mean, I've been following true crime for years, and I've been watching true crime videos for 30 years since the O.J. Simpson case. I have never seen a mirror image of a piece of evidence. Have you?
No. That's interesting because when you said mirror image, I always get confused when there's a mirror image. Like it takes me I have to look at it, and they'll say it's a mirror image, and then I have to really look at it, and finally I see what they mean. So when you say mirror image, it's the opposite of what you're looking at.
Right. Yeah. So we thought the whole time that we were looking at one side of the car, but we were really looking at the other side of the car.
And it's weird because it's mirror image, and to me, I thought mirror, that means the same, but no, it means it's a like mirror, it's backwards.
Flipped.
Yeah, flipped.
And not only that, beyond that, there was a little time stamp way up in the corner. This little time stamp, and some of the times were missing. In other words, it wasn't sequential. It didn't go 12 o'clock, 12:01, 12:02, 12:03, and I forget the exact numbers, but it was the equivalent of going from like 12 o'clock, 12:01, 12:02, 12:23.
When is the prosecution going to rest? I mean, when are they done?
Well, they took a long little break at the end, and then the judge came back and announced that the jury will get the case the last week of June. The jury will get the case the last week of June. So I don't know. I question that because the prosecution has been you should stick around for the next episode. The prosecution has been very, 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 very tedious and slow. And I really hate to disparage anyone. I want to maintain my objectivity. I promised to do so in the beginning, and I'm going to as best as I can. But I know trial work is tedious. I used to do a lot more than I do anymore, but there's just long breaks while he goes back to his desk and looks at a file and then tries to find a paper and then brings the page. It's just tedious. It's tedious. I just want to pick up the TV and throw it.
Oh, I wish I could stay for
That's all right.
For Karen Reed. I just feel like I would be more distracted.
All right. No problem. I understand litigation pressure. Trust me.
And I feel like this mediation brief is just hanging over my head.
Mhm.
But I did get the outline. I printed out the outline for
All
it,
right.
but I do want to stay on top of it. So
Okay. Maybe
I'm
next week.
I'm definitely going to watch the video that you guys do on Karen Reed.
Okay, maybe next week. I'll touch base with you then, and hopefully
Yeah.
Forensic might be back out of her
Yeah.
storm. I hope she's all right.
Okay.
She's in the snowstorm.
What?
She's in the snow globe.
Oh, there you go.
Maybe she's in a snow. No, it's not. It's June. It's not. You never know, though. In New England, you never know.
Hailstorm.
Yeah.
All right.
All right.
I'll
Have a
see
good
Nice
one,
you.
meeting
Yoli.
you, Yoli.
Bye.
Bye.
Bye.